Hi there, and welcome to the Employment Law Show once again this week. Good to have you along for the 30-minute ride. You're going to learn a lot. We can promise you that. John Scholes here, Lior Samfiru right there as well. Employment Lawyer at employmentlawyer.ca. Reach out anytime. It's a simple phone call, 1-855-821-5900. Help at employmentlawyer.ca as well. And there is a website you should go to. In fact, it's the only one because people spend way too much time blogging and going to Reddit and going to Google when you only need to go to pocketemploymentlawyer.ca. That is truthful information right there. It has everything you need, including access to the severance calculator. But we'll put that to use a little later on in the show. And we always have a main topic every week as well. This week it is workplace problems an employment lawyer can help you with. That's coming up in the second segment. So we got a whole bunch of stuff to go. Emails, phone calls. It's a busy show. But we always start off, Lior, with the week that was, or case of the day, whatever you want to title it. What do you got going on this week?
John, I am talking employment law today. I'm going to change it up a bit. We're gonna cover this topic. Kidding, of course. Always want to talk employment law. Always want to help people with understanding their workplace rights and make sure that they know they're not alone if they're facing a workplace issue. There's so many things we can cover on this show, and we try our best to cover the gamut of topics. But if your topic is not covered, we'll give you the contact information so you can reach out to me privately. We can have that discussion, and I can help address those issues. Remember, if you lost your job, the law comes in and helps you. There's entitlements that you have you may not even understand or appreciate just how significant they are. If your employer is not treating you properly, well, they should, they must, and the law can make sure that that happens. Of course, if you're not getting paid properly, your employer is not paying you overtime or vacation pay, guess what? The law says, you have to get paid properly. I think you get the idea. Whatever the issue is, we have some of the best employment laws in the world right here. And if you don't pursue those, if you sit back and let your laws disappear, it's such a waste, it's such a shame. I don't want anyone to do that. That was the whole reason behind starting this show all these many years ago. So if you're dealing with the workplace issues, there's solutions. It's not the first time that issue has happened, and the law knows how to address that. And of course, remember, just because your employer says something or does something doesn't mean that they know their own obligations, or doesn't mean that it's right. It's your job to ensure you understand your legal rights. It's your job to pursue and enforce those rights. No one's going to do that for you. And on this show, we'll give you all the resources that you need to do that. But of course, as I said, reach out to me so I can roll up my sleeves and my team, and we can help you get those issues done and resolved. But now that we know what we want to do, I say we do this. Let's talk about a case that came across my desk over the past few days. I had a gentleman call me who was actually calling me because he was concerned and upset that when he was let go, the company was not paying him his accrued vacation days. So he had accrued about 10 vacation days, and the company said, no, we don't have to pay those to you. He said, yes, you do. They were going back and forth. So he called me wanting to understand, hey, I was let go. Do they have to pay me my 10 accrued vacation days? Well, the answer, of course, was yes, they have to. If you accrued vacation, they have to pay that to you. You don't lose those. But forget that for a second. That wasn't really the issue I told them that you should be concerned about. Let's talk about your severance. Oftentimes people call me not realizing that the issue they should be concerned about is their severance. This was a prime example. This guy had worked for the company for 3 years, and they offered him 4 weeks severance. Now, he was owed 6 months severance, but it was actually worse than that. The 4-week severance that they offered him was his salary only. Well, he also had a bonus. He also had a car allowance. He also had a condo that he got to stay in rent-free as part of his compensation. So what does that mean? Your severance has to include all components of your compensation. So salary, bonus, benefits, in this case, the condo that he was staying in, that value for the 6-month period has to be accounted for. So he was calling me about a few accrued vacation days. He was owed tens of thousands of dollars in severance that he didn't realize that he was owed. I'm going to help him. I was so glad he called me about vacation days so I can help him get his full severance, not just the vacation days. Very, very common situation. Too often people don't realize that the big issue that they're probably not getting, that the employer is not probably addressing properly, is severance. It's not so much about vacation days. It's not so much about accrued overtime. They have to pay those things, but they're likely also owing you a lot more severance. Please, anytime you're let go, regardless of what you think about the severance package, you may think it's great. You always call me. Chances are it's not actually close to being adequate.
You know, there's always confusion, Lior, between vacation days owed and vacation pay. Are they two separate things, or they just lump them together when it comes to severance package?
Yeah, so they're actually different things completely. Vacation pay and vacation days are different things. So vacation pay is actually pay that you get when you're not working. Vacation days is time off work. They don't have to correspond. So you can actually lose vacation days. If your employer has a policy, you have to take your vacation by this time, and if you don't take the vacation, you can lose your vacation days. What you cannot lose is vacation pay. So your employer may say, well, you didn't take your vacation, so those days are gone. We're simply going to pay you that money that you would have earned had you taken those days. So vacation pay, in some situations, well, in those situations can you lose? You will not lose vacation days, i.e. time off work. Potentially you could, based on your employer's policy.
The situation's interesting, too, because you mentioned a condo that was provided by the employer, and that made me think right away. We've had phone calls and emails in the past on the show, and our radio show as well, where it's been landlords who have been let go from the job, and they said, yeah, but I was always included that, that ground level apartment for the entire time I've been there. I assume that would count for them as well, or at least a monetary equivalent if they were let go, right?
Yeah, superintendents, I see that all the time. You work in a building or a condo building, and as part of your compensation, you get to stay rent-free or reduce rent within that building. Well, guess what? That is part of your compensation. So if you're let go, of course, the value of that apartment that you had has to be accounted for. So your employer either has to allow you to continue to stay in that apartment for the severance period, however long that severance period is, or if they're not going to allow you to stay, they have to give you the monetary equivalent. So if it costs $2,000 a month to rent a similar apartment, well, they would have to add another $2,000 a month times the number of months of severance. All components of compensation have to be included. So the best way to know if something should be included is you simply ask yourself, would I have received it if I'd continued working? And
big ticket items as well, like for instance, salespeople, if it was a provided car that they got, would they now lose access to? Right?
So if you have a car, company car that you can use for your personal use as well, that has to be included. If you can't, if you just use it for work and nothing else, it doesn't have to be included because you're not going to be working anymore once you've been let go. But if you have a company vehicle, you take to the cottage on the weekend, you drive your family around, and it's your car, essentially, the value of that car has to be included for your severance.
We get to our phone calls, and they come from either our radio listeners, by the way, employmentlawyer.ca, to find a radio market near you where you can tune in every week. We've been doing that show for years and years as well. We got great listeners like you, our great viewers, and they always phone in and ask questions. We'll get to our first phone call for this show right now. Listen up.
I was temporarily laid off 10 months ago. The job that I was at, I have not quit yet, but they have not reached out to me in any sense, whether to settle anything or to tell me whether I'm coming back or not. So I'm wondering what my rights are for that.
How long did you work for the company total?
17 years.
17 years. And what kind of a job were you doing and how old are you?
51, and I'm in sales.
How do you handle that one?
Completely illegal. Everything we heard on this call is illegal. First of all, let's start with the very, very basics. Your employer does not have a right in most cases to put you on a temporary layoff. Even if there's legitimate business reasons, even if they're struggling, maybe the business is slower. In most cases, that temporary layoff is not legal. You can consider that to be a termination and get the company to pay you your full severance. Now, this guy's been gone on this temporary layoff for 10 months. Clearly, this company is hoping he'll just go away and they won't hear from him, and now they won't have to pay him severance. Of course, it doesn't work that way. It's illegal. He knows better. Why? Because he called us. So he is owed severance. Same with you. You don't have to be waiting for 10 months. You can consider potentially your temporary layoff as a termination on day one, okay? You can say, no, I'm not okay with that. I want my severance. So we know he's owed severance. The last thing we need to now figure out is how much severance he's owed. For that, I'm going to go and use the severance calculator tool. You'll find that at pocketemploymentlawyer.ca. I'm going to use that right now to show you how much severance he's owed. So we know this gentleman has been there for 17 years. It's a long time. He's 51 years of age. Company's not offering severance. They're hoping he's going to go away. You see right there, he's easily owed right around 16 months of severance. 16 months of severance. Company has not let him go. But based on what they've done, he has a right to consider that a termination because a temporary layoff, not legal, and that's what he's owed.
You know, if I've asked you this before, Lior, I don't know if we've mentioned on the TV show, but if, say he loves a job, he's a company guy, likes to muck in and help out, and is there anything he could do? Say, guys, okay, I'll sit at home for a few weeks, but that's the only time I'm doing this.
So in most cases with a temporary layoff, not really possible because it's so extreme what the company is doing. They're putting you off work. You can say, well, you know, I'm going to only accept this one time. It's not something I like to do. In most cases, if you accept that temporary layoff, regardless of what you say to your employer, you're potentially giving the company the right to do it again and again, and you don't want that. Who wants to be in a situation where you go to work for a few months, come back on the layoff, and go back again? Not a good way to work or to live. So that's why in most cases, for most people, it's better to consider a temporary layoff as a termination.
And that is phone call number one. Phone call number two is coming up next. Let's listen.
My question is basically, I've been working at a company. It's been fully remote. It's been about 1.5 years. In my contract, it says that location of work is to be at home, online and stuff. Newer employees are now going to hybrid. Are they able, even though my contract says that I work from remotely, if they're able to say, okay, you know, it's time to go back to the office?
So the real question is not so much can they say that. The real question is what happens if the employee refuses, right? So let's talk about that. If you're a remote employee, whether you're a new employee that's been hired on a remote contract or you've been remote for years, maybe because of the pandemic, if your employer tells you now you have to come back into the office, whether it's every day or some days, you can say no and you can't be punished for that. But remember the general rule. Your employer is allowed to let you go pretty much for any reason as long as severance is paid. So could they say to you, hey, employee, if you don't come into the office, we're going to let you go with severance? They can, just like they could for any reason. What they cannot do is say, well, if you don't come in, we're going to let you go for cause, no severance. Or if you don't come in, we'll consider you to have resigned. They can't do that either. But with severance, they could potentially terminate. So you ultimately have to decide as an employee what is better for you. Are you better to go into the office, or are you better potentially to be let go with your full severance? That said, in some cases, and I've seen this happen again and again, when you tell your employer, no, I'm not coming in, they may back off and they may leave you alone. Now, I don't know what your specific employer is going to do, which is why if you're in that situation, you're not sure how to respond to your employer when they tell you to come in to the office, let's talk about it and let's assess your entitlements individually.
And Lior, just quickly as an aside, we're well past the time where an employer can lean into the, well, we just had you off of the pandemic, you got to come back now. That's expired a long time ago, yeah?
Absolutely. So the pandemic was a unique set of circumstances. So an employer could have said then, well, we put you on remote work in 2020 because we kind of had to, but that time is gone. Probably by 2022, at the latest, they could have called you back to work. And if they didn't, and you're still working remotely, it's now a term of your employment, which means you cannot be penalized or punished if you say, no, I'm not coming in. I'm going to stay working the way I have been for the last few years.
Workplace problems and things an employment lawyer can help you with. That's on the other side of a break, which we'll just about get into now. And our third phone call for the show is coming up as well. As we continue more of the Employment Law Show, stay with us. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show continues. John Scholes, Lior Samfiru. Reach out to Lior and his team anytime with any questions or problems. 1-855-821-5900. Help at employmentlawyer.ca and pocketemploymentlawyer.ca is the only website you need to go to. Covers a lot of what we do on the show, and you'll have access to the severance calculator. I believe at last count there was over 2 million Canadians have actually used the calculator, so it's pretty robust and pretty accurate as well. But main topic's coming up in just a minute, but we have one more phone call to get through, Lior, so let's get to that now.
I think I may be in a constructive dismissal situation. I helped pioneer a company, and the agreement was at a certain stage that we would add people underneath me. And now that we are to that stage, instead of adding the people underneath me, they have decided to bring people in beside me and split up the territories and change the entire commission structure.
And how is that going to impact you financially?
It's going to cut my commissions in half.
Ooh, that's a lot.
It's a lot. So this is a change to your compensation. Certainly it's a change to compensation structure. A change to your compensation, a negative change. No one's going to complain, of course, about an increase in pay or a promotion.
Sure.
But a negative one to your compensation is not allowed in most cases, certainly if it's a significant one. It's what we call a constructive dismissal. So it doesn't matter if the company is not directly reducing your pay. If they're changing the compensation structure in a way that the effect of that is you're making less money, that could easily be a constructive dismissal. So the options here would be he can, of course, continue working and hope that he can try to make up the money somewhere else, or he may be able to consider his employment as being terminated, again, constructive dismissal, and get his full severance. I see that often with commissions, when commissions are cut, reduced, eliminated, or maybe the structure is changed. You used to be 100% salary. Now you're somewhat salary, somewhat commissioned. Whenever your compensation changes in a significant way, certainly the structure, not allowed, and if you accept it and continue working, you're potentially giving the company the right to do it again and again and again. Please don't do that. Let's talk about constructive dismissal if that happens to you.
And again, thank you for all the phone calls you give us each week here on the show. We love them. Main topic time, that's what we're going to go to now. Workplace problems, Lior, an employment lawyer can help you with. Number one, enforce your right to accommodation.
Yeah, so the duty to accommodate is a very important legal obligation that an employer has. It's the duty that happens when you have a medical condition, when you need to be provided some support because of that condition. But it's not limited to medical conditions. It could be in a situation where you may need some accommodation based on your religious beliefs, maybe to leave work early or come in late because you have to be in church or synagogue or whatever the appropriate thing is for you. There's also accommodation based on family status where you need some support and flexibility for your employer because you're caring for a child. In all those situations, we have human rights legislation that obliges your employer to provide that accommodation, to provide modified duties or hours, or give you the time off that you need. And if your employer doesn't do that, they may say, we don't want to, it's too hard, it's not our problem. Well, guess what? Talking about an employment lawyer, once they hear from me, all of a sudden, the tune changes completely. All of a sudden, what wasn't possible yesterday becomes possible today because they know we've called them on it. So if you're not being accommodated by your employer, if your employer won't support you despite your doctor's note or despite your religious beliefs, let me talk to them. Usually just hearing from me is enough. And of course, the other thing we can do, if they certainly still refuse to accommodate you, we can get you damages, compensation, get you out of there. Either way, we need to talk.
Second item that an employment lawyer like Lior can help you with, this is review an employment contract before you sign. That's the key word, yeah?
One of the most important documents that you will ever sign is your employment contract or your employment agreement. Too many employees don't realize that it's really such an employment agreement. They take a quick look at it. Okay, I asked for this salary. They gave it to me. I wanted 3 weeks vacation. They gave that to me. What more is there? I'm happy. Where do I sign? Not so fast. There are many things that are more important than if your salary is $2,000 more or less, or if you get 2 or 3 weeks vacation. There could be a term in the employment agreement that could limit your severance entitlement so much that it could cost you tens of thousands of dollars, even hundreds of thousands of dollars. There could be terms in the employment agreement that allow the company to put you on a temporary layoff, or to change your job, or to change your pay, to change your hours. And there's many other terms like that that are hugely, hugely problematic that have nothing to do with your salary or your weeks of vacation. So I review contracts all the time, and my job is to make sure you understand what your employers put in those contracts so you can understand what you're actually going to be agreeing to. But beyond that, to help you negotiate those terms. Oftentimes, when we do this correctly, it could easily be changed and negotiated. Don't ever assume that just because you've gotten an employment agreement that your employer wants you to sign, that you're stuck with it. In most cases, you're not. It can be negotiated. It starts by giving me a call.
Point number 3, Lior, step in and protect your rights if changes are being made to your job.
Yeah, so an employer does not have a right, and I alluded to this earlier, does not have a right to make significant changes to terms of employment. They can't just reduce your pay, demote you, change your hours, even change your location in a significant way. That's a constructive dismissal. But in many cases, you don't want to leave. You just want your employer not to do the thing that they're doing. As I said, once they hear from me, and once I say to them, hey, that's not legal, you're not allowed to change the shift hours for this employee, they will back off. They will say, okay, fine, well, we won't do it. So we can help with that. But ultimately, if that's not what your employer wants to do, we can pursue it as a constructive dismissal. We can get you compensation and get you out of there. That's probably, John, one of the top 3 things that we do as employment lawyers.
Well, then this last one, Lior, might be number 1 where an employment lawyer can help you. And that is when the job ends, maximize your severance pay when you're let go, right?
That is number 1 by far, for sure. The majority of what we do, what an employment lawyer does, is help those individuals that have lost their jobs to get their full severance. And the reasons we're needed for that, the reason that there's a basis and a need for us to do this as often as we do, is because in 90% of cases, 90%, whatever you've been offered, not even close to being adequate. And I'm not saying, well, they should have offered me a year's pay, they offered me 11 months. That's not good either. But that's not what I'm talking about. In 90% of cases, that 12-month severance that you should have gotten, they've offered you 3. So please do the right thing, do the smart thing. It's not difficult to improve that severance. As long as we know what we're doing, as long as we approach this the right way. I don't want anyone accepting that severance offer without speaking to me first. Every single week, sometimes daily, I get contacted by people when they hear me on radio or see me on TV and they realize they made a mistake when they accepted that severance offer and they're asking me to help now. I can't help in that situation. Once you've already signed that offer, speak to me before you sign anything.
All right, one more short break. More of your questions on the other side, and employment rights rapid fire to wrap up the show as well. So stick with us. We're coming right back. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thank you for hanging through the break. Employment Law Show continues. Reach out to Lior. By the way, 1-855-821-5900. Help at employmentlawyer.ca. Terminationquestions.com. That's where we're going to go now. Another free and anonymous website for you to ask your questions. For this week, Lior, it goes like this. I've been let go after 2 years in an IT position. They gave me only a week of notice because they consider me to be a contractor. Am I entitled to anything else?
Very common scenario, so common when someone is misclassified. They're being called a contractor when in the eyes of the law, they are employees. Remember, if you have a regular job, you go to work, you do your job, you come home, you are an employee and it doesn't matter what the company calls you. You don't become a contractor because the company that you work for says that you are. That's a misclassification, which means in this case that he's owed full severance like an employee would. They don't get to avoid paying that by calling him a contractor. Same with you. So last thing we need to know here is, well, how much severance? Because he's an employee, what severance does he get? I'm going to go one more time to the severance calculator. You'll find that at pocketemploymentlawyer.ca. And let's see how much severance he's actually owed. So he's in IT, worked there for just over 1 year. And of course, in that situation, the company says after that year that he gets 1 week's pay, we see 3 to 5 months of severance. That's how much he's owed, as much as 5 months' pay. That's where you go to pocketemploymentlawyer.ca and use that severance calculator every time.
We still have time for a live stream question. By the way, join Lior and the rest of his team in the live stream, YouTube and Facebook at ST Lawyers is how you do that. I've been off work for 1.5 years due to a medical condition. My doctor has now cleared me to return to work with some restrictions, but the company is saying I may not be ready to come back. What are my rights here?
It is not the company's call. It's not their decision. They have no say as to whether you're ready to come back to work. No say whatsoever. The only one that gets to say if you're ready to come back to work is your doctor. So, John, what does that mean here? It means that they have to follow what your doctor says. If you've been cleared to go back to work with restrictions, without restrictions, that is the final word, and your employer has to make that happen. They may have to accommodate, of course, if you have restrictions. Maybe you need modified duties or modified hours. Maybe you need the ability to work from home sometimes. That's okay. As long as your doctor says that's what you need, your employer gets to do or has to do that. What they don't get to do is to say, we don't agree, so you're not ready, so stay off work. They have no say in that. And if they try to impose something that's contrary to what your doctor says, that could be a human rights violation. It could be a constructive dismissal. It's illegal, so you have to call me.
All right, the last part of the show every week, we put Lior in the hot seat, and it's that time again right now with Employee Rights Rapid Fire. Let's get to it. Okay, Lior, number one in the rapid fire questions, can an employee refuse to accept a negative performance review?
Well, the way to look at it is it's not about accepting or not. If it's a negative review and you don't agree with it, I want you to say so, send an email saying why you don't agree with it. If it's correct, then there's nothing you need to do other than try to improve. So you don't need to worry about accepting or not. The key is to respond if you don't agree. If you respond, it cannot be held against you.
Rapid fire number two, can an employee pursue a wrongful dismissal if they don't get proper severance? What do you think?
Well, absolutely, because that is what a wrongful dismissal is. A wrongful dismissal is simply a situation when you've been let go and have not been paid your proper severance. It really has nothing to do with why you were let go or when you were let go. It's really about the severance. 90% of people, when they're let go, have been wrongfully dismissed. They're owed more severance. You can and you should pursue that. And guess what? It's not difficult to resolve.
Rapid fire number three, you're going to love this one, Lior. Can an employee be let go for announcing a pregnancy or taking a maternity leave?
No, and let's throw another no in there. Absolutely not. You cannot be let go because you've announced you're pregnant. I'll add that if you're a father, that you're about to have a child, you cannot be let go because you're going to take that leave of absence. It's illegal. Your employer cannot do anything to you in that situation other than congratulate you and have the job waiting for you when you're ready to come back to work. If they do anything, that could be a violation of several statutes. The law takes that very seriously. If that happens to you, I hope it doesn't, but if it does, call me right away.
And finally, can an employee refuse to be monitored electronically?
Well, generally speaking, John, an employer can monitor what you do during work hours as long as it's limited to work hours and work activities. So they can monitor you by having a camera in your office if you're working in an office, or monitor what you do on the work computer that you have when you work remotely. As long as it's tied to the work that you do, it's okay. Of course, they can't decide or look at what you do off work hours. That's completely off base. If it's tied to work, yes, their employer has some flexibility to monitor.
So it's different than my ankle bracelet. I'm kidding. I don't know. I'm kidding.
We don't
We're
talk
done.
about that. No.
That's right. Thank you so much for joining us this week. Thank you for contributing to the show. Reach out now to Lior and his team anytime. 1-855-821-5900. Help at employmentlawyer.ca. And we'll catch you next time right here on the Employment Law Show. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed.